Hello everyone, this is Jennifer. In this video, we're going to look into the Economic Laws Indian Patent Act. So, what is a patent? A patent is basically a document which is generally issued by the government giving monopoly right to an inventor to use his invention for a limited period. Okay, so for example, I have invented something and I get a right to sell those inventions for others for the sake of earning profit. So when I sell those inventions to others, I have a certain limited period wherein I can sell those inventions to others. After a certain period, it will become a government. It will get back to government on to becoming a public domain. Okay, so the person to whom patent is granted is called a patentee. It gives the patentee an exclusive right to use, manufacture and sell his invention for a limited period of time. So the Patent Acts 1972 along with the Patent Rules 1970 along with the Patent Rules 1972 came into force on 20th April 1972. So it basically replaced the Indian Patents and Design Act 1911. So there are basically three rules of patent rules under the WTO, which is the World Health Organization. So there's something called as TRIPS, which is the Agreement on Trade Related Aspects of Intellectual Property Rights, which is an international legal agreement between all the member nation of the World Trade Organizations. So this TRIPS is an intellectual property rights, which is an international agreement administered by the WTO. So under that, basically three rules are there. First is patent protection. So the TRIPS agreement requires the WTO members, which is a World Trade Organization members, to provide protection for a minimum of 20 years from the filing date of the patent application for any invention, including the pharmaceutical product or processes. And prior to the TRIPS agreement, patent duration was significantly shorter than this in many countries. For both developing and developed countries, provided for patent right terms ranging from 15 to 17 years, and in certain countries, developing countries, there were shorter terms which is from 5 to 7 years. So the patent protection was 15 to 17 years for some developed and developing countries, and for some developing countries it was 5 to 7 years. So basically the TRIPS agreement, which is under the WTO, requires countries to protect patent protection for both processes and products of all kinds of technology. Second one is protection of data submitted for the registration of pharmaceuticals. So pharmaceuticals is nothing but it is relating to the medicinal drugs or preparation of use or sale of the medicinal drugs. So how do you basically protect the data submitted for the registration of pharmaceuticals? So the TRIP agreement requires that WTO members protect unclosed test data submitted to the drug regulatory authorities for the purpose of obtaining the market approval against unfair commercial practices. So basically they protect the data submitted by the members of the WTO for market approval, whether they can sell this particular medicine in the market or not. Okay, so that data is also being protected under the WTO patent rules. So the third one is transition period. So the TRIPS agreement provide for transition period, permitting developing countries an additional time to bring changes in the national legislation and into conformity with TRIPS provisions. So there were basically three transition period. First one happened in the year 1995 to 2000 transition period, at the end of which all the countries were required to implement the TRIPS agreement. The second one was 2000 to 2005 transition period, which allowed certain countries to delay providing product patent protection in the areas of technology which have not been so protected at the time of TRIPS agreement. So these countries were allowed 5 years to put in place a proper patent regime of tech for the technologies and the products. And the third transition period allows the least developing countries until 2006 to implement their obligation under the TRIPS agreement in view of the economic and financial and administrative constraints. So next, moving on to the intellectual property. So what do you mean by intellectual property? It is a product or creation of the mind. For example, a painter or an artist paints something, okay, and he sells that painting, then it becomes an intellectual property. So it is basically a product or creation of the mind. Whatever he thinks, he basically puts it in his painting. So an artist, whatever he draws becomes an intellectual property. So intellectual property rights, IPR is a body of the developed to protect the creative people who have disclosed their invention for the benefit of mankind. So this protects their invention from being copied or imitated without their consent. So nobody should copy their invention. So some examples of intellectual property would basically include artist, musical, film, literary works, which is basically of creation of symbols, design, phrases, inventions and processes with the help or creation of the mind. So what are the types of intellectual property? So the types of intellectual property are as follows, which is copyright, patent, trademark, geographical indications, industrial design and cyber. So copyright is basically a term used to describe the right that creators have over their literary and artistic works. So it basically includes to protect the authors from the author's books, music, paintings, sculptures and films, and also data programs, databases, advertisement maps and technical drawings from illegal marketings or from illegal buying. So basically protecting their artworks and literary works. So it only includes the literary and artworks. Patent is an exclusive right granted for any invention. So for example, a light bulb. So if someone has introduced or invented it, so he gives the right of others to use it or to invent it or redesign it. So patent is an exclusive right granted for any inventions. Trademarks. So trademark is a sign capable of distinguishing the goods or services of one enterprise from those of the other enterprise. Example can be your Nestle, Cadbury, Google, Walmart, Microsoft. So when you look into this trademarks, it's obviously the cost of the goods, the quality of the goods will be very high. So it's basically a sign distinguishing the goods or service of one enterprise from the other enterprise. So you can distinguish from a normal Google products and from products from other, or an Apple product or a Samsung product. So it basically distinguishes how the product quality, design, everything will be. It's a trademark which distinguishes one product from the other. The next one is geographical indications. So geographical indications and appellation of origin are signs used on goods that have a specific or geographical origin and possess quality or reputation or characteristics that are essentially attributed that to that place of origin. So for example, if you see Darjeeling tea, so it basically includes the name of the place from where it's originated from. So it's a reputation, it basically shows a reputation of that particular place from where it is originated. Or Kashmir saffron or black rice of Manipur, or Swiss watches. So various examples are there. Or one of the biggest example that could be is Kanjipuram silk sarees. So silk sarees are very famous in Kanjipuram. So it basically takes into the geographical locations where it is originated from. So industrial design, an indication design constitutes the ornamental and aesthetic aspect of a article. So basically, the Industrial Design Bill 1999 replaced the Designs Act 1911. A design may consist of three dimensional features. One is the shape or surface of an article, the other one is the patterns, lines, or colors. The social purpose of this is to protect the result of the investment and the development of the new technology, thus basically giving the incentive and means to the financial research and development activities. So one example could be the aeroplanes, inventions of the aeroplanes, designing of the aeroplanes, etc. The next one is cyberspace. So some of the copyright issues involved in cyberspace are related to the interaction between websites, service providers, and consumers for the purpose of e-businesses. So these basically includes linking, framing, and catching. Legal and economic and public policy research should be undertaken to determine the extent to which intellectual property rights have to be protected in this cyberspace. So basically coming up with fake websites, so that all needs to be reduced. So example could of cyberspaces could be Amazon, Flipkart, etc. So moving on to our next slide, which is invention. So inventions mean any new and useful art, process, method, or manner of manufacture, or machine, apparatus, or other article or product produced by manufacturer, and includes any new and useful implement of any of them. So it basically coming up with something new which has not existed before. Okay, so invention can be of product or process that involves a new invention step. So thus for any invention to get patent rights, it basically should fulfill three aspects. One is the novelty, next one is non-obviousness, and how it is being useful in the market or to the society. So inventions which are not patentable. So basically there are three inventions kind which are not patentable. What are not inventions? So which are the things which are not considered to be inventions are the invention which are frivolous or which claims anything obviously contracting to the established natural laws, so which are contract contrast which are basically contrary with the national laws. Such inventions will not be considered by the government as an inventions. Second one is an invention the primary or intended use or commercial exploitation of which could be contrary public order or morality, or which causes serious prejudice to human, animal, or plant life, or to the health or to the environment. So anything which causes serious injuries to any of the living animals or living things, so that invention will not be considered. So the mere discovery of a scientific principle or formulation of an abstract theory or discovery of any living thing or non-living substance occurring in nature. So coming up with discovery of a living thing like human beings, these kind of inventions are not accepted. Then the mere discovery of a new form of a known substance which does not result in the enhancement of the known efficacy of that substance, or the mere discovery of any new property or new use of a known substance. So already it's existing, but still you come up with a new process which is quite similar to it, or which is already known, just a little transition in it. So these kind of things are not accepted as invention. A substance obtained by a mere admixture resulting only in the aggregation of the substance, of the properties, of the components thereof, or a process of producing such substance. So basically by mixing or merging of two or three substance resulting only in the aggregation of the properties of the components. So mixing up two things and coming up with another thing is not accepted. So the mere arrangement or rearrangement or duplication of known devices, each functioning independently of one another in a known way. So rearrangement of the known devices functionally and coming up with different kind of process, that is also not accepted. A method of agriculture or horticulture is not considered as invention. And next is any process of the medical, surgical, etc., which renders them from free of disease or to increase the economic value of that particular products. So such things are not considered. Plants and animals in whole or any part thereof other than microorganisms, but including seeds, variety and species, essentially biological process for production or propagation of plants and animals. Then a mathematical or business method or a computer program as per the C or algorithms are not accepted. A literary or dramatic, musical or artistic work whatsoever, including cinematograph works and television productions, are not considered to be an invention. It's just a merely literary artwork. A mere scheme or rule or method of performing mental act or method of playing game or a presentation of information or topography of integrated circuits or an invention which is in effect with the traditional knowledge. So these are not accepted to be our invention according to this particular act. Then invention relation to atomic energy not patentable. So no patent shall be granted to the respect of any invention relating to the atomic energy. Next, invention where only methods or processes of manufacture patentable. So only to the methods or process of manufactures are patentable. Other than that, invention relating to other kinds are not patentable. So patent, who is entitled to apply for patent? So under section 6 of the act, an application for the patent for any invention can be made by any of the following person, either individually or by jointly. So by a person claiming to be true or the first inventor. So first inventor can go for a patent right application. Second is by any person being assignee of the person claiming to be the true or first inventor in the respect of the right to make such application. So an assignee of the inventor can also go claiming to be the true and first inventor. Third is by a legal representation. So if the person who was invented has gone, then a legal representation can go after his invention to take an application and provide a patent to his invention. So patent procedures, so these are the various patent procedures, how to file for a patent. So first one is filing of application for patents. So the first point is filing of application for patent. So section 7 of the act deals with every application for patent shall be for one invention only. So one application for one invention only and shall be made in the prescribed format and filed in the patent office. No person resident in India shall, except under the authority of the written permit, can file an application outside India for the grant of patent. So if they are outside India, they cannot file any application for the grant of patent. So an application for the patent for the same invention which has been made in India, which is not less than 6 weeks before the application is filed outside India. So the non-resident of India who is living outside the country can file for patent in India only under two conditions. So the first one is the invention should be within 6 weeks before the application is filed outside India. And if there are no secrecy direction given under the act, only in these two cases they can file outside India. and they have to file in foreign filing license under the prescribed format with detailed description of the invention and the drawings and with prescribed fee. The second one is publication. So every publication is ordinarily published after the expiry of 18 months period from the date of filing of application or from the date of priority to the application, whichever is earlier. So the applicant request publication of this application prior to the normal period under the request through a prescribed form and fee. The third one is provisional protection. So on and from the date of the publication of the application of the patent and until the date of grant of patent in respect, the applicant will have privileges and rights as if the patent for the invention has been granted on the date of publication of application itself, and the patent holder will be entitled to receive reasonable royalty from the manufacturer to whomever he is basically giving it for use. And the provision is advantageous to the applicant for the purpose of claiming damages from the date of advertisement. The fourth one is request for examination. So according to section 12, the request for substantive examination by applicant or any other interested person has to be filed on prescribed form with the prescribed fee after the publication of the patent application, but within 48 months from the priority date of the application or from the date of filing the application, whichever is earlier. So the applicant will be examined on filing the request for substantive examination. So if the request is not filed, the application shall be deemed to have been withdrawn from the applicant. On receiving a request from the examination, the controller refers the application and specification and other documents to the examiner. Ordinarily, it is within 1 month from the date of publication or 1 month from the date of request for examination, whichever is later. So what all do they examine? Basically, the examiner submits the report of the controller ordinarily within 1 month but not exceeding 3 months. The controller would then dispose of the report ordinarily within 1 month from the date of receipt of such report and issue the first examination report. So the first examination report is very ordinary, which will be issued within 6 months from the date of the request of the examination or 6 months from the date of publication, whichever is earlier. The next one is grant of a patent. So when will they be granted a patent is once all the requirements are met with the examiner is satisfied. Then the post grant opposition proceedings may follow within 1 year from the date of said notification. The grant is notified in the patent journal published weekly by the Indian Patent Office. Then the opposition to the grant of patent under section 25, the Indian patent system provides 2 opposition proceeding, one before the grant of the patent and one after the grant of the patent. So the grounds for pre and post grant opposition are the same only, namely wrong obtaining, prior publication, prior claiming, prior public knowledge, obviousness, not an invention, insufficiency, failure to file the information, convention application made within 12 months, etc. So all these on this grants, opposition to grant will be basically opposed and it will not be granted for a patent. And the next step is pre-grant opposition period. So the pre-grant opposition procedure. So if the pre-grant representation may be filed by any person within 6 months of the date of application or before the grant of the patent, whichever is later. So the pre-grant opposition proceeding may be carried out in panel with the examination proceeding when they do not give the grant soon after 6 months from the date of application. So at that time, the opponent is required to submit all the statement and evidence if any, in support of representation and request for a hearing if he desires so. The next one is post grant opposition procedure. So the post grant opposition procedure initiates within the notice of opposition filed by the opponent, who is an interested person, within 1 year from the date of publication of grant, along with full written statement and evidence to the controller. So an appeal may be made against a decision for the by the patentee to file a reply statement and evidence within 2 months, failing which the application sometimes may be abandoned. So this time period is basically extensively by 1 month, failing by which the application will be abandoned, and this time period is extensively provided for the request for the extension to be filed within the 2 period months. So in this, they have to reply evidence filed by the opponents is to be strictly confined to the patent's evidence. So further evidence may however be filed with the leave of the controller. All the documents will be handed over to the opposition board, and controller takes decision against hearing along with the members of the opposition board. Once after the decision is heard, an appeal may be made against the decision before the appellate board within 3 months from the date of the order. So moving on to the next topic, which is Foreign Exchange Management Act 1999. So foreign exchange, what do you mean by foreign exchange? So foreign exchange is basically an institution or which basically helps in the conversion of one country's currency into another. Okay, basically dealing with currencies of different countries. So in order to regulate foreign currencies, the Foreign Exchange Management Act 1992 came into existence, so which was introduced basically to simplify and amend the law relating to the foreign exchanges with the objective of promoting external trade and payments, and for the facilitation of the development and maintenance of foreign exchange trade, rationalization of tariffs, and liberalization of Indian investment in India. So basically this law is introduced in order to facilitate the foreign exchanges. So why basically a country will get into foreign exchanges? So when they are getting into import and export, when they get into trade activities with another country, the payments will happen in different currency, so they need to convert into their home currency. That is one of the main reason foreign exchange comes into picture, and rationalization of tariffs, of taxes, and liberalization of Indian investment in India. The features of Foreign Exchange Management Act. The first one is Foreign Exchange Management Act basically came into picture in order to replace FERA. FERA is nothing but the Foreign Exchange Regulation Act. The second one, need of the hour. It had become the need of the hour since FERA had become incompatible with the pro-liberalization policies of the government. Third one, new management regime. So FEMA has brought a new management regime of foreign exchange consistent with the emerging framework along with the World Trade Organization. Then the transaction for external trade. FEMA served to make transactions for external trade, that is the exports and imports, much easier, and basically it extends to the whole of India. Scope of FEMA. So in FEMA, the transactions are basically categorized into two accounts. One is the capital account and the other one is the current account. So the capital account basically tracks the net balance of international investments, or in other words, it can also tell, it keeps a track of flow of money between the nation and its foreign partners in investment, etc. Whereas the current account tracks the actual transaction, that is the exports and the imports. The second one, areas requiring special permissions. So it lays down the areas requiring special permissions of the Reserve Bank or the Government of India on holding or acquisition of the foreign exchange. The third one, it provides power to the Reserve Bank for mentioning the categories of capital account transactions and limitations in foreign exchange that is basically admissible for the transactions. So where all the Reserve Bank can take its power. So it basically FIMA provides those powers to the RBI. Fourth one, it gives full freedom to the resident of India. So in order to hold, own or transfer of foreign security immovable property situated outside India and acquired when he was the resident. The next one, it is a civil law and contraventions of this law provides for arrest only in the exceptional cases, and FEMA does not apply to Indian citizens outside India. There are important definitions under the Act. The first one is authorized person. So, who is an authorized person? He is an authorized dealer or a money changer. So, or any other person for the time being authorized under the section. So, who deals with foreign exchange or foreign securities. Next is currency. So, currency according here means all currency notes, postal orders, money orders, checks, drafts, travelers' checks, letters of credit, bills of exchange, promissory notes, credit card, or any other similar instrument which are notified by the RBI. Then as the currency notes basically includes both cash in the form of coins and bank notes. Then person will include an individual, Hindu undivided family, a company, a firm, an association of persons or body of individual whether incorporated or not, and every individual judicial person not falling within any of the preceding subclauses. So foreign exchange means a foreign currency which includes the deposit, credit, balances, drafts, travelers checks, letters of payments which are drawn in Indian currency but payable in foreign currency, or which are basically drawn by person outside India but payable in Indian currency. In both the concept we deal with it. Next is foreign security. Foreign security means any security in the form of shares, stocks, bonds, debentures, or any other instrument denominated or expressed in foreign currencies, and also includes securities expressed in foreign currency but wherein the redemption or any form of return such as interest, dividends is payable in the Indian currency. So, what are the objectives of FEMA? So, the objectives of FEMA are as follows. The first one is provision regarding dealing in foreign exchange. So, a provision regarding dealing in foreign exchange. So, according to section 3, only the authorized person and the government terms can deal in foreign exchange in India. So, according to this act, except with the general or special permission of the Reserve Bank of India, no person can deal or transfer or make payment in foreign currencies. The second one, provision regarding holding of foreign exchange. So, according to section 4, no person in India shall acquire, hold, own, possess or transfer any foreign exchange, foreign security or any movable property situated outside India, exception as per provisions of the Act. Next, provision regarding current account transaction. So, according to section 5 of FEMA, there is no restriction regarding sale or deal in foreign exchange from authorized person if it is a current account transaction. Next, for provision regarding capital account transaction under section 6, RBI will fix the limit of foreign exchange transaction relating to the capital account along with discussion with the Indian government. Any person may sell or draw foreign exchange to or from authorized person for capital account transaction. Next is provision regarding export of goods and services. So, according to section 5, it is a duty of the exporter to declare the true and correct detail of goods which he has to sell to the market outside India and must send complete report to the RBI. Next, provision regarding authorized persons. So, according to section 10, RBI may have an application which made it in its behalf authorize any person to be known as an authorized person to deal in foreign exchange or foreign securities. When that is done, he has to follow the rules and regulations of the RBI. Next, provision regarding contraventions and penalties. According to section 13 to 15, if anybody or person contravenes the rules and regulations of the FEMA or RBI, he will be liable to a penalty 3 times sum or involved in the contravention. If contravention continue, then he will have to pay 5,000 per day during the time of contravention. Next, provision regarding adjunction and appeal. So, according to section 18, central government can appoint adjuncting authority who can give the punishment of civil imprisonment of maximum 6 months if case is less than 1 crore. If it is more than 1 crore, then the imprisonment will go on beyond 3 years. So, thank you everyone.